Good afternoon, everyone. My name is Suli Encalada, and I am the Business Development Manager with Castle Group. And welcome to our webinar today, Ballots and Bylaws, Running the Community Association Elections Without Headaches. And joining me today, we have Jonathan Goldstein. He's an equity partner at Haber Law, and I'll allow Jonathan to introduce himself.
Thank you so much. First of all, I'd like to thank Suli, Millie, Reagan, and the Castle team for inviting me to join today and to collaborate on this webinar. This is a great topic, and I hope we can be as informative as possible. As introduced, I'm an equity partner at Haber Law. I'm board certified in condominium and plan development law, and I co-chair our firm's condominium and plan development law practice group. So thank you.
Thank you, Jonathan. We also have Regan Marok. He's the Business Development Manager for the Broward region, and Mil Ventura for the Business Development Manager for the West Palm Beach region,
Hi, everyone.
joining us today as well. All right. Just a couple of housekeeping. If you do have any questions during the webinar, use the Q&A button, and those will be monitored and will be bring it up as we speak, or if there are too many, then we will leave them towards the end. Okay. All right, so let's get right into it. So again, Jonathan, thank you so much for joining us, and let's go to the first question. So Jonathan, annual elections, they aren't just important, they are mandatory for condominium associations and HOA. Now, can you explain why the law requires them and what purpose do they serve to ensure good governance?
Sure. So first, I'm excited to do this presentation concerning elections because this is such an important and timely topic. And, this is a fundamental aspect of community association governance. Associations are like a type of private self-governance, right? They're like a private mini government where the members control their own destiny. And that element of self-determination doesn't exist if members can't determine who's going to lead the association. So this is like at the heart of what a community association is all about, whether it's an HOA or a condo. There are laws that ensure that eventually condominium members or HOA members can control their associations, that turnover is required. This is fundamental to the whole concept. And so elections are required. They increase accountability, right, by ensuring that directors can be removed, replaced, depending on how they perform. They increase, in transparency. It gives a voice to the membership. And by the way, there are other potential ways that the laws could have set this up so that leadership can be chosen. It doesn't necessarily have to be the specific type of formal election process you see in the Condo Act. In HOAs, it's a bit more flexible, governed by the governing documents. If they're different, and the Condo Act procedures are very technical, with very specific requirements. And those very technical requirements are required to ensure transparency on the one hand and consistency in how these elections are conducted, to ensure they're fair, to regulate them, to create a good process, but also to protect each member's right of secrecy in casting those ballots. And again, that's in the Condominium Act. HOA, a lot more flexible. So we'll be talking about that throughout.
Right, thank you. Now, speaking about that, how have elections evolved in the recent years, and why are boards facing now more scrutiny?
Oh yeah, it's evolved tremendously, last, 10, 5 years, and even in the last couple of years. It seems every year it gets a little more complex. There's new wrinkles added. I think there's a couple of trends to highlight. First, there's been a big push to encourage online voting. So electronic voting using the internet or apps, right, to cast ballots remotely. This is meant to enfranchise members. And in general, there's been other trends, such as the stuff that happened at the hammocks, right, that has increased scrutiny on board governance, on association governance. And so there's a push to empower the membership, right? And so, you see the criminalization of more conduct by directors, and that includes creation of criminal penalties relating to election misconduct, very specific laws, that govern election misconduct and actually are crimes, right? And I would say that there's kind of a little bit of a trend in the HOA Act to be more and more condominium-like, which has not yet fully transferred over to elections, but I see in the near future that that could happen. There's kind of a little bit of a push in the future to that there's kind of been a little bit of talk that in the future they might try to incorporate condo style elections into the HOA Act going forward. So we'll see if that ever happens, but I think that could be a trend, to structure elections even more.
I
Um,
have a question for you, Jonathan, because you mentioned, that there's a big push for online voting. And recently I heard something about that with the new upcoming changes, that there was going to be email voting. And how does that, like, there's supposed to be secrecy, right? So how is that going to change things if, if the whole process of having voting is to maintain
Correct.
secrecy? Yes.
Right. Yeah. So this is kind of like a clash of values of where on the one hand there's secrecy, but on the other hand there's the desire to push for member enfranchisement, to be able to participate remotely how the member wants to. And so this year in the Condo Act, you're right. The HB 913 created a mandatory method of email voting if an association does not already have online voting, right? So in online voting, you use an app, a vendor to process online votes in a way that can preserve their secrecy for the elections, in a way that, it protects owner information. There's all kinds of legal requirements for that. But if an association doesn't have that, the new law now requires associations to permit submittal of ballots by email. Now, in that case, the owner is waiving their right to secrecy because that's the only way email voting can work. And what it literally allows is for an owner to sit there and send an email with their ballot that shoots it to a designated email address of the association, and then the association has to make sure they cobble together all those emailed ballots and count them in the election. For sure, it's more complicated. I think it's meant to steer associations to adopt online voting finally. Email voting is going to be a cumbersome and burdensome requirement, for management companies to keep track of it, to have email addresses. It's going to affect the notices, right? Like online voting and email voting, they affect the notices you send because, your first notice has to alert people that online voting is available. And now your second notice is going to have a special form of ballot for email voting if you need to accept that type of ballot. So it's a big change, and it's a kind of bizarre. I'm not a huge fan of email voting because of how
Right.
it can be tricky it can be to administer,
Yes.
perils of it. There is questions of like how do you authenticate that the email really came from. So it's
Right.
it's kind of there's issues,
Correct.
right, and how it'll be adopted. We'll see if it flies, but that's the law now. So associations that don't have online voting, now's the time to put it in place if you don't want to collect email ballots.
And talking about
Yeah.
putting it in place, I know there used to be a 14-day requirement for you to adopt a resolution. What is the new requirement now, Jonathan?
Really good question. They're no longer, they took it out. In HB 913, they removed the 14-day requirement for the meeting at which that resolution will be considered. You still need to do an online voting resolution. So just to give the quick primer, when you want to have online voting, there's a process you need to do to implement. You can't just like sign up a vendor, start doing it. You have to have a meeting where the board votes with a quorum to formally have a resolution that establishes online voting, right? And it should probably reflect certain policies about it, like certain details about how it's used, but doesn't necessarily have to. That resolution used to have to be done at a meeting on 14 days of notice, but no longer. This year's law took out the 14-day notice requirement, so it could theoretically be posted on 48 hours notice, and then the board can vote on it that way. So it makes it much easier, and it shortens the runway, so to speak, to get online voting off the ground.
Yeah. And that same topic. So how does that process generally differs from, in the case of an HOA versus a condo? How is it different?
HOAs are a little different. First of all, they're very different, I should say, because they're not necessarily governed by the statutory process and regulations, right? So in the Condo Act, you have a statute that governs elections, you have administrative code regulations adopted by the division. All of this creates a very technical election process that must be complied with. In the HOA Act, what it says is the elections are governed by the governing documents, right? And so the governing documents will control HOA elections much more so. And the statutes, they only provide certain guidance. They don't specifically govern the exact details of the process. So, for example, in the HOA Act, there isn't a requirement for this whole secret ballot for 60-day notice, 14-day notice. There isn't this whole technical election process I'm sure we'll go into for the condominiums. You could potentially have votes by secret ballots at the meeting or by limited proxies, right? And so, or by a general proxy, and then the proxy holder casts a vote at the meeting. So there's a lot more flexibility in HOA elections. You can also have online voting, but how you administer online voting, depends on your nomination process and how you nominate individuals. Because if you can do nominations from the floor, there's a question of how you would employ an online voting system in an
Yeah.
HOA election, right? Another thing is in mixed use communities and master associations, you often see sub associations that have voting representatives. So the voting representative can cast like all the votes for that particular building or condominium or sub association. And so there's representative voting often in HOA context, right? So that's more common in HOAs and can cause, a little bit of confusion over who votes. Is it the members directly? Is it the rep? Right? And so all of those things come into play with HOAs.
Oh, wow. It can definitely be challenging for sure.
Yeah,
Now,
definitely.
comes election time. Now the notice is out. Now, ahead of the election, when the managers or even the board is preparing the package. So what kind of, what type of information should they start preparing or gathering before the annual meeting, like the board and the property manager? So what type of information should they start gathering to be prepared?
Advanced preparation is more important than
Mhm.
ever for like some of these reasons we've already talked about. First of all, it's important to always have a handle on what the bylaw requirements are for elections and annual meetings. Like, for example, in a condominium or an HOA, the bylaws will typically tell you when your annual meeting must occur. So you want to have that in mind from the get-go, all year. You want to have that in sight and plan accordingly. Online voting has a ramp up. If you want to have online voting at an annual meeting or election in a condo, you need to alert people of this opportunity in the first notice. So that means you're going to have to be ahead of the first notice to use online voting at that election. Similarly, you want to be planning in terms of voting certificates. Many associations have voting certificate requirements, which means for units with co-owners or multiple owners, or for units owned by corporations or maybe even limited liability companies or partnerships, the owner has to designate who's authorized to vote. Some associations, that's not required. For co-owners, maybe they decide amongst themselves. Other associations, it is required. But maybe spouses don't have to designate someone. It's very technical, and it's a good thing for the association to be aware of because if an association hasn't been collecting voting certificates, right, that could be an issue. You want to be organized about it. That's something to be prepared for in advance. And that outreach can be important, especially with new members, who come in. A big issue to be aware of is suspension of voting rights.
Yes.
Because suspension of voting rights in condos is very regulated, requires a certain timeline of notices and procedures to even consider it. And so if you have an owner who's been delinquent, they're over $1,000 delinquent, 90 days, the association may want to suspend their right to vote in the election, and that's allowed. There's certain technical issues relating to whether it's allowed in a given case we'll get to, but assuming it's allowed, you need to follow a very precise procedure to do it. And most importantly, 90 days ahead of the annual meeting, notice has to be given to all the owners that we can suspend voting rights at this election. It's like an advance notification that suspensions are in play here. Pay up, you know? So
Yeah.
that's something that can easily be overlooked. And it's like if it's 60 days before time to send the first notice and that suspension notice hasn't been sent out, you can't suspend voting rights.
Yeah, and I think that's something that quite a few associations tend to forget. And that's something obviously that they should be reaching out to the legal counsel about is the suspension of voting right, because then it comes the time to receive their ballots and they say, oh, no, you can't vote. Well, but they never send out the actual notice of
Sure,
suspension.
that's something to
And
get way ahead of. If a board's
Mhm.
interested, they should ask legal counsel to talk about it with them months and months in advance.
Yeah.
Hi, Jonathan. I do have a question from the participants. Can you further explain how or what is a representative voting?
Oh, that's
Sure.
great.
Yeah, sure. So like I said, in the context of condos and HOAs, a unit will designate a representative to vote for the unit if there's like co-owners or an entity. So that's like a voting certificate that designates a voting representative for that one particular unit owner. But if you have like a sub association, like say you have a master association and there's a bunch of different like lots in the master, it, and there's like three neighborhood associations, which are, sub associations within that master. How is the master's board elected? Well, maybe the sub associations don't vote through each unit owner individually, but vote through a representative that represents the entire sub association. So that neighborhood association, that's what they're often called, will have a voting representative. Unlike a representative for a single unit, that representative represents the entire association or building. And that person can be elected by the members, can be the president, depends on what the governing documents say. I've seen governing documents where the president is the voting rep, always. I've seen governing documents where the members elect the voting rep, unless there's no election and then it's the president. And these can be little things that have to happen at the sub association level. So it's good because sometimes the condo association or the sub association must coordinate its efforts and plan ahead and take certain actions to enable the members to vote through a representative in the master association election. This issue comes up all the time in bigger associations with different sub-associations or in mixed use projects with neighborhood associations. So it's a really important question. And representative voting works on two levels, at the specific unit level, but also sometimes for the sub-association level.
Now, let me ask you in that same topic, is that the same as when there's commercial units and they have a representative for all those commercial units, or that's a different one?
Yeah, that's great. So that can work similarly to either. So like let's say there's a commercial lot within a master association. It's a mixed use project. That commercial lot, like a condominium unit, right, may have to designate a voting representative, like it through a voting certificate.
Correct.
But similarly, if you have like a commercial condo or you have representative voting where there's a sub association with commercial units, they may, as a group, have to designate a voting representative or elect one or have one. So it can work both ways for commercial
Okay.
lots, just like residential lots.
Okay. Sounds good. All right. Thank you for the clarification. It's good to know. All right. So again, in preparation for this annual meeting, how early should notices of elections and candidate solicitations, because that's important as well, should go out?
Well, this is a technical question that's governed by the Condo Act and administrative regulations in the condo context, and that's 60 days, not less than 60 days. Some governing documents may, say more, but it has to be at least 60 days prior. That first notice will notify members of when the election is going to be and that online voting is available, if it is, and it notifies members of their ability to run for the board and submit their candidate application forms. I always, sometimes associations want to go it alone in preparing that notice, but given all the requirements and technicalities these days, probably a good idea if council does it. But that first notice, is standard and required in condos. In HOAs, it depends on the governing documents. You may not even need that kind of first notice. Depends on how nominations are done. HOA decks or governing documents can, in the articles or bylaws can say how nominations get made. It could be in advance, in which case there's no right to nominations from the floor, and then you might have to submit a nomination form like in a condo. Or it can say nothing, and then maybe nominations happen at the floor of the annual meeting. So it depends on the governing documents.
And Jonathan,
And now,
because we're talking about notices, so if somebody doesn't have online voting and now they have to, go with the email voting, how is that notice given? How many days in advance? When is that notice provided?
Sure, the members are going to have to get it's going to be an adjustment to the notices that are sent. I think it'll be mostly adjusting the second notice, excuse me, at the ballot level, where when you have when you have email voting allowed, I think the second notice will have to tell everybody what the designated email address is for those ballots. There's probably a separate form that will be included in that second notice for email ballots, because the law now requires certain information in those email ballots. So like the second notice won't just have the typical ballot anymore. It'll also have, if you plan on emailing your ballot, here's the ballot to use for email ballots. So, and it'll have a whole explanation about it. So this is something that I think will get integrated into the second notice. It may not, it could be good to include something about it in the first notice. I don't, may not typically be required. Online voting, though, has to be in the first notice. The first notice has to advise the members of their ability to use online voting. So you can't like throw together online voting, before the second notice, but like after the first. If you haven't included it or factored it in the first, it's too late for that particular election.
Got it.
awesome. And now with that notice, now who's responsible for confirming that notice are sent correctly and on time?
Yeah, I mean, that's one of those things where, like I said, probably these days, I would definitely have council review it, or even better, prepare the notice packages, given all these complexities. If an association, works with management to prepare that, management can always, have council take a look and make revisions. But certainly it's great idea to have legal counsel's involvement. But ultimately, at the end of the day, the buck stops with the association and its board who calls the meeting. So, the association may not get in the weeds of it. The directors may not get in the weeds of it, but they're responsible for it, which is all the more reason to use business judgment and comply with the duty of care by relying on those professionals who know how it should be done.
Is any particular seat in the board that is responsible to making sure that the notice goes out, like the
Yeah,
secretary or the president or?
typically the president calls the meeting, or the secretary. That's like as an official matter. They may
Mhm.
have final approval, right? Unless they delegate that to the manager, or the board delegates it to the manager. But I think, typically it's the president or the secretary who will sign off on
Uh,
notice
n-
packages.
All right, that's great. Now, what common mistakes do board make when preparing for elections? Are there any common mistakes that you see often
Yeah,
when they're
for
preparing
sure.
for elections?
Yeah, there are certain common themes. In terms of mistakes, and this is not the list, trust me, the list is like a scroll that goes.
I'm sure.
But no, seriously, the most common mistakes, number one, are underestimating um, the importance of voting certificates going into elections. That's a big one. Whether how they're done, that they're kept the right way, their significance at the election, and what they mean. That's why it's critical for legal counsel and management to be on top of that issue. Often boards can kind of take for granted that the most recent law applies to their elections. That's a big issue that can arise. It's kind of an open issue that's being litigated here and there, and we've encountered this where, for example, a board might assume that because the law now says that a unit owner who's delinquent in the payment of assessment can't run for the board, that might not apply to that association. The board may assume it does, but in fact, if the documents don't have certain language that incorporates changes to existing, the Condominium Act as amended from time to time, it's arguable that that change in the law doesn't apply because it impairs vested rights. And so, those are arguments that are in court, right? Different associations are litigating those issues. So I'm not the judge, but I will say that it's an argument that, potentially shouldn't be overlooked. And if associations want to have certain eligibility criteria that's been added to the law since their declaration was recorded, if you don't have Kaufman language that says the law is amended from time to time applies, you may want to talk about amending the bylaws to add those criteria to make sure there's no issue with applying it. So those are two of some of the bigger issues. Another big issue is not preparing in advance. Like, for example, the suspension of voting rights 90 days before, right? Not setting up online voting in advance and then wanting to use it. And then, whoops, it wasn't done before the first notice. So I think those three things are pretty common mistakes, unfortunately, that can happen. Another mistake that can be tricky is assuming that the bylaws track the Condo Act, right? Or not following the bylaws. So, like, for example, maybe your bylaws require the second notice to be sent 25 days in advance of the annual meeting. The minimum notice is 14 days, but the bylaws can require more notice. So that's, management and legal counsel want to get ahead of that and be aware of that, so that doesn't trip up the association.
Now you were talking about, qualifications. So what are the current legal qualifications to run for a board? And if they don't qualify, how do you communicate that a candidate, that is not eligible in order to avoid any conflicts?
Yeah,
And it's a
so
two-part question.
this is a segue from what I was just talking about, right?
Yeah.
Because the eligibility criteria for the board, very important issue, governed by the governing documents or the statute. And there is a question of which version of that statute applies. Not, that can be taken for granted, but it probably shouldn't be. So, for example, delinquencies is one. I gave that example before. And note, in the Condo Act, it's assessments only, not, monetary obligations or fines. But in the HOA Act, it's still broader. So that's an important little subtle distinction between HOAs and condominiums. Also, a person convicted of a felony, right, whose civil rights haven't been restored for at least 5 years, they're not eligible. Co-owners in a condo cannot run unless there's an insufficient number of candidates, or, they own multiple units so they can run for different units. And there may be other criteria in the governing documents not inconsistent with the statutory eligibility that govern. So, for example, the bylaws or articles of incorporation may say the candidate has to be a member of the association, right? So that could be a criteria that's commonly seen. So those are some examples, and in many cases, typically the way I'd see it is that the deadline for submitting the candidate forms is like the crucial date, right? The law pretty much says that eligibility is determined as of the date the candidate applications are due. So it's not when the election happens or the annual meeting. It's not when the first notice was sent. It's like, as of the date of the deadline to run, are you eligible? That's like that's generally the route to go. If somebody's ineligible, I would talk to counsel. I would get an opinion from counsel that, hey, this is a reasonable interpretation of this. Here are the risks of doing this. Here is the recommendations. Like, I would clear it in that way. I would do that backup. I would also have counsel or the management company give notice to the affected individual. We received your application, but you were disqualified for XYZ reason. I think that's an important step in the process, to document that notice to the individual. not just to send a package without them, without any explanation of why.
Yeah.
I think that's a best practice.
Yeah. But now let's say they find out that the person didn't qualify for whatever reason after the election took place and this person got elected. So what happens?
I think that person is disqualified, right? It could compromise the election and require a redo, right?
Okay.
That's one thing that could happen. Um, it can be fixed through resignations and people getting appointed, but somebody who's ineligible is ineligible. They cannot be on the board, right? So it may be that they have to be removed from the board because of the discovered ineligibility. Maybe the election has to be redone. There's different, scenarios that it can occur. By the way, there's some eligibility criteria that are not, they're conditional and they don't automatically apply. So like the best example of this is the 8-year term limit, right? This is a new thing. This is a great opportunity for me to just quickly talk about it because it's a big question. I'm sure we'll get a question from
Yes.
somebody about the 8-year term limit. It's inevitable. So I'll answer it now. The 8-year term limit in condos says that if you've served 8 consecutive years, you cannot run for sit for a 9th year unless, big unless, so there's a way you can continue, unless you are approved at an election by 2/3, right? So basically, you have to get a supermajority vote in order to continue to serve. So this is like, it's one of those things where it's not automatic that you can't run. Many people assume that, oh, I can't run because of the 8-year terms. But actually, that's not how it works. You can run, you're on the ballot, but you need to get a larger vote. You need to get like an overwhelming support. The 2/3 of all votes cast in order to stay on.
Oh, okay.
Otherwise, you would not count. If somebody didn't get 2/3 and they were one of these individuals, you would then say, let's go to the next highest vote getter because that person didn't get 2/3, so they can't be on the board.
Mhm.
Plus, if there's an insufficient number of candidates, the individual can continue to serve. No problem. Also,
Okay.
this is one of those issues where Kaufman language arguably matters. The arbitration section of the division has ruled in certain decisions that without Kaufman language, this is a retroactive impairment of eligibility. And so it doesn't apply to associations that don't have Kaufman language, whose documents were recorded prior to the change in law. So the law started in 2017, and so it's starting to matter now. But if an association doesn't have Kaufman language and its declaration was like recorded in 2010, very strong argument that the 8-year term limit doesn't even apply because of Kaufman language. If the owner were to assert that, it would be a compelling issue, argument, and I would not force them to be off the board for the term limits. Now, just good disclaimer, this is not legal advice. Talk to your counsel. This is just educational and informative. That's not a legal opinion, but it's just food for thought.
I have a question from the participants, because we're on this topic now.
Yeah.
So if a board member is changing their designation or, their position on the board, does that start the count as to the years they're on the board? I would assume the answer is no, because they're still on the board and they're still a director. But the question is, if they change the position, would that restart the count?
Doesn't change anything. What office they serve is irrelevant. By the way, some governing documents kind of have funny language, like bylaws about how many years you could serve as president or this, that may apply, but it doesn't affect the 8-year term limit. Also, if you take a break, like if there's an interruption in service for like a year, then it's not 8 consecutive years, right?
Okay.
It starts from
Because
the
that was going to be my
next
question.
and
That's
it's
good.
not a
Good to know.
permanent, it's not like a permanent term limit of like 8 years and you're done forever. It's just more about 8 consecutive years.
Okay, that's
Yeah.
a good one. That's a good one because I was gonna ask that as well. So you take a break of a year or two, then you can come back and do another 8 years. So it's
Yes,
8
yes,
consecutive years. All
yes,
right. So
unless
it's
your
not 8
governing
total.
documents, the governing documents can be different. Maybe the bylaws have permanent term limits, right? Or that's a different issue than the law. But most, I very rarely see that in governing documents.
Okay, I do have some follow-up questions regarding felony, because I know we touched on this. So can the board request a background check of all board members of the board? And if you did have a prior convicted felon who is now has been restored, do they have to disclose that?
Okay, so number one, you can try to deal with this in the eligibility form, in the candidate application form. So a common practice is that the candidate application form require the candidate to certify that they comply with the criteria. So that's like they have to be honest. They're expected to be honest. If it doesn't pan out, then they're off, right? Or that's a separate violation. But does an association have to do a background check, that sort of thing? I would say arguably it's within the board's business judgment. If the candidate is certifying they comply, whether to like go the extra mile of paying for a background check, that would be a common expense. It would not be something you can require the candidate to pay as a condition to run for the board, right? It would be something the association just implements as a procedure as part of its due diligence. It would, if you're going to do that, be careful. You want to make sure you're doing it even-handedly. You can't play favorites or do it differently for anyone, right? And you want to be careful with the information collected. It's private. It's not, it's kind of like a background check for sale or lease. Arguably, it can't be a requirement. It's debatable, like if an association were to impose that requirement of like authorizing it, a candidate could theoretically say, no, I don't authorize the background check. And there's a question of whether the policy is enforceable, right? Because there's criteria to run for the board, and unless it's in the governing documents or statute, there's no criteria that says you have to submit for a background check. It's implied, right? So I think it's kind of an open, up in the air issue but I think it's one of those things where it's not a terrible best practice. It's not a terrible process to implement, but just realize that you might get pushback, and there's kind of a question of how far you can push it and enforce it. But the criteria are the criteria. If somebody's a felon, then now, as far as disclosure, that's something to talk to legal counsel about, in the given instance. But there's significant issues with potential, it's not something I would necessarily be disclosing. It's something that the private information obtained in any background check cannot be disclosed generally. So it's like, talk to legal counsel concerning what you must or, cannot do in relation to any kind of eligibility criteria.
Thank you. I also had a question. There was a question from one of the participants. If you had a board member who doesn't follow ordinance, can they still be on the board? My assumption would be that if you follow the violations policy and you have a number of violations, a board member can't have a certain number can't be delinquent. And I'm assuming also can't have violations. Or do you want to clarify that, Jonathan? Because I'm not certain on that.
There's no criteria that prohibits running for the board with violations. So,
Okay.
I mean, arguably, there's a question of whether a governing document could be amended to create it, but it would be a debatable, maybe even unenforceable change, because it may be inconsistent with the statutory eligibility criteria. So I would proceed with caution, get an opinion from counsel before doing that. Now, in the HOA context, it could be a little different. In the HOA context, it's a little more governing document oriented. There are certain criteria in the statute. It's kind of evolving. So it may be a closer call in that context. Talk to legal counsel.
Got it. Thank you.
And by the way, in the HOA context, delinquency of a fine is grounds for disqualification. So if you have a fining committee and impose fines, that's an effective way to get fines paid. And it's a way to make violations an ineligibility criteria if they haven't paid the fine.
Got it.
I think that clears it up for sure. All right. So now moving on, let's say the meeting, is fast approaching. Now you have to get quorum for this meeting. So now, for those that are new to the board, can you explain what is quorum? And, is it essential for a valid election?
Sure. So in condos, there's two different things. There's quorum, which is the governing documents. They say the minimum number of members present to do business at a meeting. And then in the Condo Act, there's a special type of participation that is not quorum, but it's like a minimum floor of participation to hold a valid election. So you could have an election in a condo without quorum as long as you meet that minimum threshold, which is 20% of the voting interests. Okay, so that's in the Condo Act, there's that differentiating 20% for elections versus quorum, say for the special meeting of the members. And by the way, most votes of members require quorum to have the meeting and vote, but the elections are special in that regard. In the HOA Act, quorum will govern. You have to have a meeting, you need a quorum in order to have an election. Although, in certain unique, if an HOA wants to like implement Condo Act procedures, I suppose it's arguable they could amend the bylaws to create a 20% floor, a special quorum for elections. It's an interesting question, that's a different issue. So, but to answer your question, quorum is percentage needed to hold business at a member meeting, but there's a special election floor that's 20% that governs instead of quorum. So you could have an election even without quorum. One important note on this, quorum, while we're talking about it, quorum can change based upon ineligible voters. So often in the governing documents, there'll be a provision that says that the quorum number can go down. The total number of units counted for quorum can go down based upon ineligibility, right? So for example, you say you have 200 units, but 10 units cannot cast votes because their voting rights were suspended, right? The governing documents could, and law could say that quorum goes down because those suspended units are not counted. What if the association owns 5 units? They're not counted. Those units, it's like they don't exist. Another common situation like that is voting certificates. Many governing documents say that if you don't have a voting certificate on file, your vote is not counted for any purpose, including quorum. This is a hidden issue that many associations don't miss out on. So if you need to meet that 20% threshold, maybe you meet it if you remove the voting certificates that aren't submitted from the pool. So for example, if you have a bunch of units that need a voting certificate because they're owned by corporations, right? And they don't have one on file, you can reduce the number of units, and that may not lower the quorum number enough to have a meeting, to have a quorum, to meet the 20% threshold. So that's some of those, that can be a sneaky issue.
Okay, so if you don't meet quorum, then obviously the meeting cannot take place, correct?
Correct, and if you don't meet the 20% threshold, you can't have the election.
Correct.
And the board, what happens is the board rolls over.
Rolls over. Okay. Now, and you said this can be changed, right? The bylaws can be changed to change the quorum requirement.
In the HOA context, yes. In the Condo Act process, the 20% floor is statutory. So you can't change the 20% floor for elections through the governing documents. You can change quorum.
Okay. And now, can you explain the notice requirement for the second notice of an annual condo election and how it's different from HOA for the second notice?
Yeah, sure. So, by the way, one thing to mention is quorum is capped in HOAs by statute.
Oh.
That's something that can get missed also. Some HOA boards are like, well, I want 50% quorum. No, it can't be over 30%. So to answer your question about second notices, first of all, in the condo second notice, you have to take into account the email ballot issue if you're going to have email ballots. And additionally, the condo second notice is very regulated pursuant to the Condo Act election process, right? So you need to have certain kind of ballots, inner envelope, outer envelope, so that it complies with all the regulations governing Condo Act elections. You need to, the ballot has to be a certain form, has to comply. The notice should explain that process in a simple way. And so the HOA Act second notice is going to be more governed by its governing documents. What that process, so it may say, here are the candidates. You can vote by mail or online voting. It may say nominations will be taken from the floor and you can vote by secret ballot at the meeting. It all depends on the bylaws or articles of the HOA. So those notices are a little more flexible, and it depends on the circumstances of the particular association. And in the Condo Act, you have other things to take into consideration, concerning some of the legal requirements for elections. And one other thing to keep in mind with the Condo Act is there's a process to appoint a committee. Well, I can talk about this when we talk about the committee that counts
Yeah.
ballots, but you can give notice in advance, 48 hours in advance, not necessarily in the second 14-day notice of the annual meeting, that a board meeting will be, a committee meeting will be held to start the process early. So that's, something. Also, one thing to keep in mind for condos that is really weird is that starting this year in the new change in the law, if there's going to be Zoom in the annual meeting and the election, you need to have a quorum of the board members in the room physically at the meeting location. This is kind of a weird thing, but you want to take it into account at the first and second notice level by scheduling the meeting when the directors are there. By the way, I don't, one common question is, do you think this would postpone an election if the directors didn't comply? And I would say, no, I'd hold the election anyway. You know what I mean? They're different. Typically directors aren't needed for an election or an annual meeting because it's a member meeting, but it's a weird new requirement. I'd be remiss if I didn't mention it. But just it's something to be taken into account that the directors have to be available and in the room. Also, the new laws require that for Zoom meetings, if you're going to have Zoom, you need to have the Zoom link. You need to have the top conference number on the notice. So the agenda and notice for the annual meeting are affected by some of these new legal requirements. All the more reason for management and legal counsel to be involved and, carefully, follow the laws on that.
And from what I understand, Jonathan, if you do have a Zoom meeting, you still have to provide a physical location for owners to.
Absolutely. Yep, that's very clear now. That was kind of an
Yeah.
open issue, but I always recommended it anyway. But yes, for sure, totally required, And by the way, one might ask, well, you talked about Kaufman language and which version of the law applies. Why do I have to do this stuff with Zoom meetings if we don't have Kaufman language? And actually, some types of laws don't mess with people's rights. They just establish procedures, and the Zoom stuff is procedural. It applies to all condos. It's retroactive. I think this is just my 2 cents, but I think it does because some of it's procedural. But if it does affect substantive rights, one might argue you need Kaufman language. But putting the link to the Zoom, requiring people to be in person, to have it in person, that to me is procedural. I think it applies to
Yeah.
everybody.
And speaking about procedure, so is there any special procedure in the case of an association that had developer owned units or mixed use condos?
Yes, great. Yeah, really important question because there's often tricky little things in the notice and ballots when you only have certain seats up for elections by certain groups. So, for example, in a developer situation, you might have a developer that still has a right to have a seat on the board because they still have units owned in their name and held for sale in the ordinary course of business. So you need a ballot that excludes that developer seat and doesn't put that seat up for election, right? Because the developer gets to appoint that seat. Similarly, in a mixed use condo, the commercial units cannot control a majority of the board or vote on a majority of the board because the residential owners have to be able to, vote to elect the majority of the board. This affects the ballots because you're going to have a couple of seats or maybe a seat that everyone can vote on, but you're going to have seats for a majority that the commercial units, shouldn't be able to sway. So that's got to be dealt with at the second notice level as well.
Yeah, because I do remember a couple of condos where they have like mixed use and like there was a seat specifically for that commercial unit, and they will stay there forever. You couldn't remove it, so that was a good one. Now you were speaking about the committee for counting the ballots. So are there any suggested best practice regarding the counting committee and its role in verifying the envelopes on counting the ballots?
Sure, yeah. So that independent committee, right? It doesn't include it can only include certain types of people who aren't like connected to the candidates or the board members, right? You can't have like the board member or the candidate or their family member, serve on that committee, obviously for bias reasons. That committee can be can be called to a meeting right before the annual meeting or in advance of the annual meeting so that they can begin the process of pre-verifying the outer envelopes. That's a special meeting you can notice so that people can be in attendance and watch it. And in that earlier meeting, you can get a head start on like sorting through the outer envelopes. The whole condo election process requires a process of verifying that unit owners are voting through going through the outer envelopes, the voting, the roster, checking off who voted, making sure they're owners, making sure voting certificates on file, all that kind of stuff. Actually, there's a question of what about signatures? The law does refer to that. So it's a good best practice for an association to always have new owners sign a roster, in which case now you have that list of signatures. Obviously, we're not handwriting. I'm not going to ask an independent committee to be handwriting experts. Okay. And if the association doesn't have the signatures, what can you do? And an owner would have to complain about that. I'm not going to like force committee members to like invalidate people because the signature. You got to be careful with that kind of thing. I think a lot of the goals of this is you want to enfranchise the owners. You don't want to be like abusive in the invalidation. It's got to be through the letter of the law. It's got to be good reason. That's defensible under the regulations and statutes. For example, there's no signature on the outer envelope, or there's no voting certificate on file, and it's required, that kind of thing. There's all kinds of little things that can come up. It would take an hour just to like talk about the nuances of the actual election day process. But sure, best practice would be having the early meeting to get a head start. You'd want more than one. I always feel like if possible, if you only have one, that's fine. I don't like management to serve on the committee personally, especially not alone. Management can help the committee and so can legal counsel and like kind of, be available as needed. But like, I think the committee should be owners. That's what it says, of owners. So that's an important detail. And there's a lot more to that process. There's all sorts of little tricks of the trade, so to speak, in terms of how you sort, but suffice to say, it can be a painstaking process. So it's important to have that roster ready. I think a good best practice is for management to talk with legal counsel a couple days before, week before, about having the records in order to facilitate that process as smoothly as possible.
And sometimes if it's a contentious, election, it's worth it to have an election monitor.
Yes,
it's
the
not that
association-
expensive and,
Sure. The association can hire them, or owners can petition for an election monitor with Florida, and the ombudsman's office will appoint one, right? You need a certain number of votes to petition for that, but that's also something that can happen. And the election monitor, they're not going to call balls and strikes, but they're gonna orderly do this, do the process, consulting with legal counsel as needed, and they're going to err on the side. I typically find that they err on the side of trying to enfranchise voters if it's not like a material problem. But if it's a material problem, they'll be very clear and openly announce when they're, disregarding a particular envelope. Now, of course, online voting goes hand in hand with this. You want to note when you're cutting off online voting, because technically, ballots can be submitted until the outer envelopes are open and everything's been. So I like to coordinate the online voting in terms of the timing and when it gets shut down. You want to have the capability to shut it down at the same time. And you want to make sure you're not getting votes like after it's been shut down. You want to make sure you're announcing it very openly. Also, it's very important for the committee to like work with council and management so that there's no double voting. You got to double check the online voting voters versus who cast the ballots there versus, so that you're not getting two sets of votes. And another thing that has to be remembered is online voting need voting certificates too. So you're not just going through the outer envelopes, you're going through the online voting list for voting certificates as well.
Thank you for that. And only because we were talking about committees, I did have a question from the participants. Can someone who is on the POA board of a condominium sit on a committee?
I'm sorry, somebody who's on the,
A
the-
POA for a condominium, can they sit on a committee? Not specifically the elections committee, obviously that's a no, on any committee.
well, a director can sit on a committee for sure. I'm not sure if I'm understanding.
That is the question. I guess which committees they cannot be on. I would assume,
Oh,
obviously,
yeah, the one committee is the grievance committee.
the Greens
You know,
committee.
grievance
you.
committees, directors, you know, they can't, and officers can't be on the grievance committees, which impose
you for that.
fines or suspend use rights.
And I know we're running short on
And
time, and I
also
have
the independent vote committee.
Got it. We're running short on time, so I'd like to get some of these questions out of the way. Sully, I know there's a whole bunch of questions that we
Yeah,
have
no,
as
of course.
well.
Yeah,
But you know, I'd like to get all these cleared out. So another question came in, you know, can a board take a loan in a period of less than 6 weeks before the election?
I'll be quick about that. That's not something that's really governed where it says no. Maybe governing documents governs it, but I'm not going to categorically say no.
Okay.
Or yes. I'd have to look at it as legal counsel for the legal counsel for the association would have to, but there's nothing that prohibits that. There's no like, you cannot take a loan within that I'm aware of.
Okay. And then also, is there a law for the HOA for the condo where quorum is needed in the room? So quorum of the board members in the room, is that for HOA or condo? I believe that's for HOA.
Well, for HOA, you need a quorum, which can be by limited proxy or general proxy. So the proxy holder has to be in the room. And this is a good time for me to mention proxies really quick. And answer that question. Proxies can be tricky. There's a lot of mistakes that happen with proxies where owners fill in the name on the line and that person doesn't show up and they're not in the room. Well, they're not counted for quorum. Owners put in their own name on the proxy. That's not a good proxy. I see these types of defects, and associations and the directors and the management need to be aware, like you don't want to count proxies that are invalid or where the person's not in the room if they're written on the line. So that's an important step with proxies to make sure that the designated proxy holder is in the room or has substituted somebody in the room. If it's left blank, it's typically the secretary who's the proxy holder. But I don't like, I prefer the form say any officer, including the secretary or president, because I don't want a situation where none of the proxies are good because they left it blank and the secretary got sick and can't be in the room. There's a question now, especially in condos, but also in HOAs, of whether Zoom is in the room. If the board approves it, there's a way under the Not-for-Profit Act that Zoom can be treated as in person. But it's tricky and complex, more complex than you realize because of voting. If you do that, then people can vote. So they don't need a proxy to vote. They can vote on the internet. How are you going to do that? How are you going to count the votes? Can you verify them? So, but it has to be approved by the board to do that, and it's different technical questions. So, but I think those answer your question.
Thank you, Jonathan. Also, someone wants to know if you're running for an HOA to be on the board, can you campaign by sending out emails and distributing flyers?
If you're running, you can, subject to restrictions in the governing documents that you're not being abusive or soliciting in ways that are improper. But yeah, there's nothing, and in fact, the associations have to be careful when not to curtail speech that's protected.
Jonathan, we want to thank you so much for joining us today. Do you want to share your contact information? How can they reach out to you for more questions?
Well,
yes,
sure.
actually, I will share. Yeah.
I think you'll share my email, jgoldstein@haber.law. You can call me. It's been a pleasure. I thank you again. Elections are very important and tricky these days. So, you want to avoid those pitfalls and implement those best practices that we talked about. Thank you, everybody, for attending. And thank you to the Castle team.
Yes.
Regan,
thank you so much.
Julie, really appreciate this. It was great.
Yes. Thank you. Thank you, everyone, for attending. And thank you. We'll see you next time.